Police continued to give numerous lawful orders to get into the police unit, and she did not comply. Police drive-stunned Sherrard to gain compliance, which was successful. Now, as we've discussed before here on ATA, whether or not the use of force during an arrest or investigatory stop of a free citizen is quote-unquote excessive is analyzed under the so-called reasonableness standard of the Fourth Amendment, which guarantees citizens the right to be secure in their persons against unreasonable seizures of the person. As the Supreme Court explained in the landmark 1989 case of Graham versus Connor, although, now quoting, Fourth Amendment jurisprudence has long recognized that the right to make an arrest or investigatory stop necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it, any use of force must be reasonable under the totality of the circumstances. In the Graham case, the court noted that, quote, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight, and ultimately identified 3 factors that courts should consider when evaluating the constitutionality of a use of force, stating that, now quoting, because the test of reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application, its proper application requires careful attention to the facts and circumstances of each particular case,